All right, so today we're going to talk about something pretty cool. It's called Reg CF, otherwise known as equity crowdfunding. If this sounds at all familiar, that's because you're probably familiar with crowdfunding generally, but you'll note that that's not equity crowdfunding. So, of course, I'm talking about things like Kickstarter, Indiegogo, where you're effectively giving a gift or a donation, maybe a pre-purchase of sorts, for a product that you really believe in, you're a huge fan, but you have no skin in the game. You're not actually investing. There's no risks, there's no benefits. Well, I guess you can give money and not actually get the thing you paid for, but it's not an investment. You don't have equity in the thing that you put money into. Whereas with Reg CF, it's literally an equity investment. You're literally investing in a thing with all the risks and benefits that come with it. And so that's what we're going to talk about today. So again, it's called Reg CF for regulation crowdfunding. Now, if you're an attorney doing this sort of thing and you've never really done much with it before, this is a pretty deep dive. You're going to learn effectively all the kind of technical framework type stuff you need to know. On the flip side, if you are a startup founder and you're trying to raise money with a Reg CF round, well, you're also going to learn kind of everything you need to know about the whole structure and framework of kind of how all this stuff works. So what we're going to do is we're going to dive in and kind of unpack everything there is to know. And to do that, I've created a mind map because I'm a huge fan of mind maps. It's actually how I got through law school, how I passed the bar exam, and they are immensely useful. And in fact, if you check out my website at markhoglaw.com and you pull up the article that I wrote about Reg CF, you will see embedded in that article is a mind map on precisely this stuff, which I can send to you by email if you'd like to get the high-res copy. There's a link in the article. You can find it. Shoot me a note, and I'll shoot you back the high-res PDF, because what we're going to look at today is that PDF. We're going to go through it. We're going to highlight it on screen as we walk through it together. It is a very deep dive. It takes something around, I think, 38 minutes, give or take, but I think you're going to love it very much and find it very useful indeed. So without further more ado or a ramble, let's dive in and get started. Reg CF begins now. All right, so here is my beautiful mind map. You can print it out if you really want to, but it's not going to be legible at all on a standard 8.5 by 11 piece of paper. You'll need like a giant wall-sized canvas. So what we're going to do is we're going to zoom way in until everything becomes crystal clear and just kind of fly through all this. Now, just to set expectations, this is a really deep dive. I mean, it's pretty much all-encompassing, everything you need to know. So let's dive in, get started, have some fun. So the point of, and by the way, we're going to highlight as we go along here, just to kind of keep track, call things out that are super important. The purpose of Reg CF, regulation crowdfunding, is essentially an alternative way for startups, for people to raise capital for their companies, right? And specifically, it's to enable people to raise capital from non-accredited investors up to $5 million in a 12-month period. So to really understand where crowdfunding, equity crowdfunding specifically, so in the investment spectrum, you've got what? You've got bootstrapping at the top. This is obviously, well, not raising money by definition. You're literally bootstrapping yourself. You are pitching in all the money that you've already got, you know? Then you've got friends and family. This is when you raise funds from personal networks. Say, you ask your parents, your grandparents, your best friends, whatever. Then you've got angel investors, right? So these are obviously high net worth individuals. They do invest their own funds, and typically at a very early stage. The advantage to angel investing is that there isn't any sort of SEC registration required. It is, of course, however, subject to securities laws, as, well, frankly, all of these obviously are. And crucially, angels can invest individually or as part of large angel groups or networks. Then we come to crowdfunding. That's Reg CF. So as we just said, this allows you to raise up to $5 million within a 12-month period from both accredited and non-accredited investors. And crucially, this is done through an online platform, a portal, if you will, which, by the way, itself must be properly registered and must adhere to all sorts of strict rules, regulations, and guidelines. And we're going to touch on a lot of that going forward. Strictly speaking, the offering itself is not required to do SEC registration. It's exempt from SEC registration, but the platform itself, as we just said, must indeed be registered with both the SEC and with FINRA. Now, the issuers themselves, issuers are the startups, let's say, the companies. They do have to file a Form C, which we're going to unpack in all sorts of juicy detail in a bit. and then, of course, comply with all sorts of ongoing recording requirements. And then after crowdfunding, Reg CF type stuff, we've got the usual kind of VC, venture capital type of investments. I'm not going to go through all this because it's frankly beyond the scope of what we're here to discuss today, but suffice to say, this is, again, the typical VC route, which is typically done with a Reg D offering, and you can read this if you like. But again, the idea of this section is just to give you kind of a sense of where Reg CF falls amongst all the other investment types. So before continuing, though, let's get a sense for the various key definitions that we really need to know. And let's start with the issuer. So the issuer, for all intents and purposes, is the person or indeed the company that is trying to raise the money because, again, this is for equity, right? So they are the issuer. They are the issuer of stock, which is then given to whomever invests in exchange for equity, right? Makes sense. So crowdfunding, the term that we all know very well, is raising a small amount of money, but from a very large number of people, typically, obviously, via the internet. So hence the name crowdfunding, right? You're literally just getting almost micro investments of sorts, maybe tens or hundreds, maybe even thousands of dollars, subject to limitations, which we'll see in a moment, but from many, many, many people. And again, up to $5 million in a 12-month period. The intermediary is the broker or the funding portal that's actually registered with the SEC and with FINRA, as we said. We'll discuss some of these in a bit. Crucially, then, the investor, which is putting money into these platforms, into the various companies that they want to invest in, these are the so-called non-accredited investors. So they don't typically meet the accredited investor criteria, which, by the way, is defined as individuals with incomes exceeding $200,000 or $300,000 with a spouse, or a net worth of over $1 million, excluding the primary residence. So this is for people not accredited. So just to be clear. One brief mention is on the restrictions to the securities themselves. They cannot be resold for 1 year unless they are transferred to any one of these various categories. So the issue of the securities themselves, that is the startup that is actually raising the money, to another accredited investor, a family member of the purchaser or some equivalent thereof, perhaps in a connection with the death or divorce of the purchaser, or to a trust controlled by the purchaser or created for the benefit of a family member. These are really nuanced details. That's why I'm kind of flying through them. I just want to make sure that you are aware of them, that you look at them in greater detail later as needed. But now let's get into the really kind of fun, juicy stuff about what's what, because this is where we really unpack kind of who's eligible, right? So, and when I say eligible, I mean with respect to the startup, with the issuer trying to actually raise money on such a platform, what are the requirements? Well, there's a lot, but it's not particularly complex stuff. It's just kind of a lot of nuanced detail that you're going to have to really learn and to understand. Now, if you're a startup trying to do a Reg CF, or maybe you're interested in doing it, you want to learn more, these are just really important things you have to keep in mind. If you're another attorney looking at working with startups trying to do a Reg CF, or indeed working with another, let's say with an equity crowdfunding platform, well, you're going to want to understand these really, really well. So first of all, perhaps rather unsurprisingly, it must be a US-based company. What does this really mean? Well, it means it literally actually cannot be a foreign company. It can't be an investment company either, by the way, nor can it be a disqualified entity. So for instance, maybe it's done something illegal in the past, it's been effectively disqualified. So these are the things that it cannot be. It is worth unpacking a bit deeper. What does it mean not to be a foreign company? Well, it just means that suppose you've got a company based in Europe or in Canada, that's where the headquarters is, they want to do business in the US. Yeah, that wouldn't fly. Just doing business in the US wouldn't fly. They would have to actually create a headquarters in the US and indeed have a US-based corporate entity, LLC or corporation. But even that's not probably going to be sufficient. It's not tightly defined, but it's probably the case that simply having your headquarters in the US is not sufficient, if indeed it's just, if its primary purpose is to effectively, shall we say, funnel money to some foreign entity. So for instance, if you got a business thing, an entity technically in the US, but all the money is going to, the mothership, say in Canada or in France, for instance, yeah, that wouldn't fly. It has to be like a legitimate, actual US-based company doing legitimate, actual, business on U.S. soil, and that money is remaining here in the U.S. The investment company limitation, that it not be an investment company, what that really means is we're not looking for lack of a better word, shell companies. We're not looking for companies that just, they want to raise $5 million to then go out and acquire a bunch of failing other companies to then kind of pull under one umbrella, kind of, build and flip, as it were. That's not okay. You've got to show like a real, actual business plan. You're trying to really build a thing from scratch, an authentic, original thing, an idea, a business plan. That's what we're looking for. So if you think you can use Reg CF to just go out there, raise $5 million just to acquire and flip a bunch of failing companies, that's not going to fly. So super important to keep in mind. Now, of course, we've got to comply with all sorts of requirements. Section 4AB is the portion of the SEC that effectively enables Reg CF. There is actually a lot of things here. I hope you'll appreciate that I'm not literally going to go through and read every single one of these things, but I am going to touch on quite a few of them. So, for instance, we know that we're going to need to provide things like basic information of the company, of the founders, the business structure and so forth, the description of the business, the capital structure of the business, things like that, right? All right, so now let's dive into arguably one of the most important details of a Reg CF offering, and it basically determines the extent to which you must provide financial disclosures in order to raise the money. So let's highlight this section here because this is critically important. So the amount of money that you're raising, and that includes, by the way, what you've already raised thus far, it's going to determine which of the following four tiers you're going to be categorized as, which in turn determines what sort of disclosures you need to provide with respect to your financials. So if you've already, if in total your initial, if your offering within that 12-month period is just up to $124,000, you just need to certify your financials with your CEO or CFO. If you happen to be raising something between $124,000 to $618,000, you need to have your financials reviewed by an independent public accountant. That's a very ambitious highlighter. Sorry for that. If you're in the third tier, then that means you're raising between $618,000 to $1.235 million, in which case you need to be either reviewed or audited, again, by an independent public accountant. And if you have the audited financials, then you use those. And finally, if indeed you will have raised within that 12-month period more than $1.235 million up to the $5 million cap, then it must be the case that you provide audited financial statements by an independent public accountant. So these tiers are super important to keep in mind as, again, they determine the extent to which and the detail with which you provide financial disclosures. And when you think about it, it kind of makes sense, right? The idea is that the more money that you're trying to raise in a 12-month period, the more kind of the more scrutiny there needs to be, right? So that kind of makes sense. Again, I don't want to go through all of this in great detail, otherwise we will be here for a very, very long time. But suffice to say, you do want to read through all of these things and to make sure that you really kind of internalize and understand all of this, right? So let's skip forward for the moment down to the requirements for the investors themselves. So the question is, how much can a so-called non-accredited investor put into a company on an equity crowdfunding platform? Well, it's a really convoluted bit of logic to figure out, but here's a bit of a sort of logic tree to kind of work through it, right? So the question that you're asking is, is the annual income less than $124,000 or, not and, but or, is their net worth also less than $124,000? Well, if the answer is yes, then you can try this somewhat silly mnemonic of sorts. You follow the either or 5% more rule, which says that if the annual income or the net worth is less than $124,000, then you're going to take whichever of the following two figures is greater. It's either $2,500 or 5% of whichever is bigger as between annual income or net worth. So to be super clear, maybe think of it in the reverse. Look at the annual income or the net worth figures. Which one between the two of those is the largest? Take 5% of that number. Then compare it against 2,500. You're going to take the greater of those two values. That represents the maximum amount that an investor with either an annual income or net worth of less than $124,000 can put into the platform. Now, if their annual income is not less than $124,000 or their net worth is not less than $124,000, well, then you're going to follow the both and 10% grand rule, which says that you're going to look at the greater of 10% of annual income or 10% of net worth. So that's a relatively easier kind of logic tree to work through, right? You just look at the annual income, you look at the net worth, you take 10% of both. Whichever one is larger, well, that's the number you can go with. That's the investment cap, up to, crucially, a maximum of $124,000. So that's super important to keep in mind. Now, what sort of requirements need to be disclosed? Well, there's a form called the Form C. It sounds simple and innocuous, but it's actually quite lengthy and involved and very, very detailed. But essentially, you need to provide what's very coincidentally provided by this very convenient mnemonic, because indeed the Form C is quite literally the thing that you have to submit before you actually raise any money. So we'll just run through these very quickly. So the business information in general, right? Your description, your business plan, how you intend to use the proceeds. Financial conditions of the company. So as we just discussed earlier, the financial statements have to be certified or reviewed or audited based on, whichever of those four financial tiers we discussed above. The ownership and capital structure details, how the ownership and the terms of the securities being offered. Any sort of risk factors. This is super important. So the other ones are rather obvious, I think, but risk factors, let's highlight this, right? You need to really spell out any sort of material risks associated with the investment. And indeed, I want to flesh that out a bit deeper with some examples, but the point is you also need to include any sort of material changes with the company, right? So you have to disclose any material changes to the offering terms, and investors have to reconfirm their investment commitments if there's any such changes. And so taken as a whole, what does this really mean? Well, so look, in law generally, obviously if you're lawyers listening to this, you already know this. For everybody not a lawyer, just something to keep in mind, a good rule of thumb is anything material is something which the ordinary person in that situation would probably take very seriously. Or maybe rather more pointedly, you could say a material thing is a thing which, if it were present or not present, a reasonable person in that scenario would effectively do the opposite to which they initially intended to do. So, for example, suppose you are going to buy a house and you discover that, one of the walls has some missing paint after you've made the home purchase. And that missing paint wasn't disclosed as part of the home purchase disclosures and the seller's disclosures, right? Would that qualify as a material omission such that you could effectively, go back on the home purchase? And the answer is probably not, right? Because your typical reasonable person doing a home purchase is not going to consider, stepping back from a home purchase simply because part of the wall in one of the rooms is missing some paint. On the other hand, suppose there's a home purchase who discovers, right after the home purchase is closed, that the basement is cracking. There's actually water starting to inundate the basement, and just really, really bad news, right? Or maybe they discovered an excess mold problem in the basement. Well, I don't know. Would a reasonable person probably at that point, well, first of all, would they have been alarmed? Absolutely. Would a reasonable person probably have not gone through with that home purchase had they known the entire basement's about to flood? Well, probably, right? And maybe not probably, but it certainly is enough to give you pause to think, right? And so that's how you need to think about material changes and indeed risk factors, material risk factors. Are these things that a reasonable person would first of all want to know or indeed even need to know? And if so, and if they knew these things, might they reconsider doing the investment in the first place? So that's how you really need to think about it. I think the kind of stereotypical textbook example is obviously that, it turns out that one of the founders had some sort of there was some sort of a charge against him for some sort of securities fraud, for instance. There was no conviction, but they were charged with securities fraud. And maybe this was a few years ago. Who knows? Doesn't matter. The point is that a material thing? Well, look, in general, yes. Just assume anything involving a legal issue with a founder, especially involving securities fraud, that's definitely going to be something material, right? So, but then the question is, to what extent do you need to disclose it? Like, how much do you have to say? How much of a red flag do you have to sort of wave in the air? How many sort of big, bold, underlined sort of disclaimers do you have to put on the Form C when you file it? Well, there aren't any hard and fast rules around this. It just comes out to transparency. And what you're going to see as we get through all this is that the whole point of Reg CF, and indeed the way these portals operate, is precisely to foster transparency, and more transparency. So just something to keep in mind. Sorry to have spent so much time on that, but I think it's super, super important. All right, so we've touched on the four financial tiers earlier, and as I said, we're going to be coming back to it, and there's a reason for that, right? So we explained kind of what the four tiers are, but now we're going to unpack in greater detail how this is all done. So as we said, it's the total amount raised in the prior 12 months, including the current Reg CF offering, right? But strictly speaking, only in the Reg CF offering. So anything that the company has raised through other sort of methods, say for instance Reg D through a VC round or outside of that 12-month window, these would not impact the tier that the company falls into. So with respect to those four tiers, we've kind of gone through all these, so we're not going to do this again, but there is a nuanced distinction that does need to be made that we didn't mention earlier. So with respect to tiers 3 and 4, we're actually looking for the two most recent fiscal years of information, right? So to be clear, the amount being raised we're still looking just within that 12-month period, but the disclosures must go back 2 years. And same with tier 4, right? So that's just something really important to keep in mind. So we're always looking at the amount being raised, including the current offering, for only within this 12-month period, but the duration, how far back in time you need to include in your financial disclosures is only one, the most recent fiscal year for tiers 1 and 2, and it's the two most recent fiscal years for tiers 2 and 3. This is a bit pedantic, and I'll just sort of fly through this briefly. Make sure you understand actually how to calculate the 12-month period that we keep talking about. So what you're doing is you're counting from the start date of the current Reg CF offering. You're going back 12 months. So what you're going to do is you're going to ID the start date. It's the date of when you fill in Form C. Just count back exactly 12 months. It's the period from the date 12 months prior to the current start date. So that's all there is to that. Next up, we've got to understand what is the role of the intermediary. That's the platform, the portal where you're actually raising your Reg CF in the first place. So the mnemonic for this is simply CPEM. I just went with the first letter. It sounds like a medical device or medication, whatever. But the point is, 4 critical things, right? So the role of the platform where the Reg CF is actually happening has really 4 primary duties. So it's got to conduct the due diligence on the issuers, right? So it's got to make sure all the background checks are done and proper. It then has to provide educational materials to the investors. The idea is to inform the investors. Crucially, this is super, super crucial. The platform needs to ensure that all the investor communications occur on the platform itself. So what that means is that any sort of material discussions about the fundraising itself, about sort of any financial information, anything other than super, extremely, high level, superficial type stuff needs to occur on the platform. Because again, the idea is to maximize accuracy, safety, transparency, that sort of thing, right? And crucially, of course, all records and compliance enforcement must also be performed by the intermediary platform. So with respect to the offering itself, so the smallest amount of time that an offering can be open is at least 21 days. So in other words, if a startup is on the platform, they want to raise the Reg CF round, whatever that amount is, they have to keep it open for at least 21 days. Investors, meanwhile, they can make commitments, but crucially, they have up till 48 hours before the offering deadline to actually rescind their initial commitment. So just think about that for a moment. As a startup, you can be on the platform, you can think that you're going to get a bunch of money from, say, 20, 50, 100 different investors. Maybe one or two of those are actually giving a pretty big chunk. That's probably how it's going to go. You're going to get, say 95% maybe from 1 or 2% of the investors that you're trying to raise. Maybe not. Whatever, that's not the point. But the point is, even once they've committed, they have until 48 hours before the offering deadline to cancel, to fully just kind of rescind their initial commitment. It seems a bit weird, right? But when you think about it, it's because, they have a way of sort of committing during a so-called testing the waters phase. That's TTW. And you know about this because it falls under the advertising and the communication section of your trusty mind map. Because what does this mean? It means that, so it basically gives the investors and indeed the issuers really a way to test the waters. What are investors, are they interested in their startup? And the idea is there are quite a few strict requirements. So for example, the startup can make pre-offering communications to gauge interest from the investors, but crucially, there can't be any actual acceptance of money during testing the waters. And the communications do have to state 3 main disclaimers. So for example, no money or consideration is solicited, and if sent, it won't be accepted. There's no offer to buy securities, which can be accepted until the Form C is filed, and indications of interest are non-binding. Why non-binding? Because we just said the investors have until 48 hours before the offering deadline. So what can be discussed? Well, issuers can advertise the terms of the offering, but they must direct potential investors to the platform for more information. And crucially, again, all communication must occur through the platform. Why? Well, to ensure transparency and regulatory compliance. So again, you're seeing this recurring theme here, right? So everything with the Reg CF must effectively go through the platform. So what does that really mean? Well, look, you can be at a social mixer event. You could say, hey, yeah, we're trying to raise some money, and you can leave it at that. But you can't start to give a whole bunch of detail about how much you're trying to raise, what the terms of the offering are and so forth. That's just not okay. And this goes both ways, right? So for instance, if an investor has discovered details of what you're trying to raise and they then try to hop onto the platform to then make the investment in reliance on what they improperly heard off platform, yeah, that's also not okay. Now, obviously, we have to show a causal link. It must be the case that because they heard information that was otherwise meant to be confidential within the confines of the platform, we must show that they actually relied on that to make the investment. If there's just a sort of chronological coincidence, that's probably not a big deal, but these are details you really want to sort of keep in mind and to avoid. So not just do not discuss details off platform. Now, once you've raised your Reg CF, there is all sorts of kind of ongoing reporting and compliance things you got to keep in mind. So there is a Form CAR, which cleverly, imaginatively enough, means the Form C annual reporting. This is obviously very important, and it must be filed within 120 days of the end of the fiscal year. It's essentially the same stuff as before, but just updated, right? So updated financials, business operations, compliance status, that kind of thing. And you guessed it, if there's any sort of material change, if somebody got, sued with securities fraud, yeah, probably include that in the Form CAR. And as we mentioned before, obviously for higher tiers, this will also include audited financial statements for the past 2 years since inception. So how do you maintain compliance? I mean, look, it's a lot of common sense type stuff, right? You're going to keep accurate records. You're going to update your disclosures as necessary. Obviously adhere to all the regulatory requirements. It's also worth mentioning that issuers may in fact terminate their ongoing reporting obligations, however, if any one of these various things happen. I'm not going to waste your time running through and just reading all this. These are sort of exceptions to the rule, but the point is there are ways to terminate this ongoing annual reporting requirement. So What else here? What can we learn about sort of risk-averse compliance processes? Well, we're going to look at it from 2 points of view, right? The intermediary platform itself and obviously the issuers, right? The startups trying to raise money on the platform. Again, I don't want to waste your time reading through all these verbatim, but suffice to say, the platform itself needs to be very user-friendly. It's got to explain the limits and the consequences of any sort of misrepresentation, allowing investors to easily certify their income and their net worth to make sure they indeed qualify, and with respect to the various caps. By the way, something worth mentioning: if there's a mistake, let's suppose that a startup tries to raise, or that they actually do inadvertently raise somehow more than $5 million within that 12-month period, or let's suppose that an investor inadvertently gets lumped into the wrong category, right? Based on how they've calculated, say, their net income and their net worth. If there's a mistake made where actual dollars are handed over to a startup, this can actually and indeed must be reversed. You accidentally raised $6 million in a 12-month period? Oops, too bad. Give back that extra million. It's not necessarily catastrophic. It's not the end of the world, at least probably not anyway. But the point is, it does need to be given back. Likewise, if an investor accidentally gets lumped into the wrong tier, they end up, committing more money than they're actually allowed to do based on their income and net worth. Yeah, that's going to have to go right back to them. Because again, the idea, these are not accredited investors. They are quite literally non-accredited, right? And we want to sort of protect them, as it were, from, ruining their lives, making bad investment choices. It's sort of it's a safety net of sorts. The platform, therefore, needs to have a bunch of automated checks too, actually exactly to what we were just talking about, right? So it's got to have automated checks to ensure that things that don't make sense don't happen. So for example, suppose there's somebody who comes on board there and they submit that they have a very high income but with a very low net worth. Or perhaps they indicate they've got a net worth that just doesn't align with their zip code and with demographic data generally. This isn't to say that it's not possible, but there needs to be an automated sort of reality check like, hey, if you're showing that you have a $20 billion net worth in sort of Nowhereville, Alaska, with all due respect to Alaska, probably this should raise a red flag for some sort of secondary checks to make sure it's indeed accurate. Likewise, anything for self-certifications, tax returns, bank statements, third-party asset verification, all this stuff needs to be checked. There just cannot be any issues. And by the way, speaking of which, the Form C, which is filled out manually, right? I mean, effectively, right? This needs to be cross-checked with all the financial disclosures. I mean, those numbers all have to add up. So for instance, if on the Form C you see that they are showing, X percent of, how is the money being raised? How is it going to be apportioned? 10% to marketing, 30% to development, blah, blah, blah. Let's say that those numbers add up to 100% as well. They should do, but let's suppose on the financial statement there's an error. It doesn't. It adds up to like 110%, for instance, or 90%. These are mistakes that need to be cross-referenced, checked, and fixed. There cannot be discrepancies as between the Form C and any of the necessary disclosures. So super important to keep this in mind. So that's for the intermediary platform itself. Essentially, we just touched on what's happening, what happens next year with the issuers. Likewise, you got to inform about the investor limits. You got to provide accurate information. The red flags, there's got to be notifications of red flags. Multiple investments exceeding limits. That's not going to be okay. So just keep these things in mind. And as I said earlier, any sort of excess funds will need to be returned to the investors. And of course, any sort of amendments, whether to Form C or otherwise, do need to be filed. So again, if anything goes wrong, if a material thing occurs, these need to be amended. Well, the Form C has to be amended, and indeed this needs to be included in the subsequent Form CAR. Very briefly, just to keep in mind what you're dealing with here if you do any of this stuff wrong, intentionally, certainly, but even potentially negligently, right? So there is a ton of SEC oversight. There's tons of audits, investigations, and enforcement actions, and there are penalties in the form of fines. Your entire offering can be rescinded outright, and obviously there can be additional legal actions for noncompliance. So in general, do just keep in mind, basic kind of good risk management and best practices. Have really solid internal controls, have robust internal controls to ensure compliance, and crucially, above all, this is the real name of the game. It's this one. Well, I guess they're both going to highlight. That's fine. You've got to maintain consistent communication through the platform, right? Through the platform with your investors, because at the end of the day, it's about building trust, ensuring compliance. Because when you think about it, equity crowdfunding is a pretty novel concept, actually. It's pretty great that we have this. And so the point is, look, you can do it, but just make sure that you do it by the book. And there you have it. That's a wrap. That is equity crowdfunding, Reg CF in a nutshell. All right, so that is a wrap on Reg CF. Obviously, if you have any questions at all, feel free to reach out to me. You can easily find me using the links in the description below. Thanks so much for listening. Until next time, bye-bye.